Yes, Pinto.
Yes,
Sanjay Pinto.
Three caveats and two questions. I do not stand for any practice in any religion that subjugates people of any gender or age. I believe that religious symbols are an individual's right, and I respect all religions. However, the recent decision of the Karnataka High Court on the Hijab row has kindled two basic questions in my mind. The first is, how does the term essential practice, in a sense, come to be implanted into the bone of contention over religious freedom? The second is whether the wearing of a hijab attracts any of the reasonable restrictions that circumscribe this freedom. Two questions. The impugned government order, we know, which insisted on adherence to a dress code and uniform, was issued under Section 133, read with Sections 7, Subsection 2 and Subsection 5 of the Karnataka Education Act 1983 and Rule 11 of the 1995 Curricular Rules. This was the basis of the ban on entry of students wearing the hijab. It triggered a toss-up between the power of the state to impose a restriction flowing from a local enactment and the fundamental right of a citizen that is not merely granted but guaranteed by the Constitution of India. At play here are Article 25 on the freedom of conscience and the right to freely profess, practice, and propagate religion, and Article 19(1)(a) on freedom of expression. Without expression, practice, profession, and propagation are rendered meaningless. The words essential practice do not exist in the relevant constitutional provisions. For that matter, the term religion itself has not been defined in the Constitution. A judicial proceeding on a sensitive constitutional question is not a public debate. For words to be introduced to peddle a narrative or meddle with an enforceable guarantee, in my opinion, the word essential itself dilutes freedom and hits conscience. Should our courts adopt a constitutional or ecclesiastical stance in adjudication? The tightrope walk while donning a theological mantle was addressed by the Supreme Court in Young Lawyers Association versus State of Kerala 2018 with remarkable candor. The competence of the court to do so and the legitimacy of the assumption of that role may be questionable, unquote. The Supreme Court reasoned that, quote, adjudicating on what does or does not form an essential part of religion blurs the distinction between the religious secular divide and the essential inessential approach. The former has a textual origin in Article 25(2)(a), the latter is a judicial creation, unquote. Now, both the rights in question are not absolute. While freedom of conscience and religion are subject to public order, morality, and health under Article 25(1), freedom of expression is hemmed under Article 19(2) by the sovereignty and integrity of India, security, public order, decency, morality, contempt of court, defamation, or incitement to an offense. Wearing a headscarf is a deeply personal choice based on a religious belief, in my opinion. It can offend no one. How can an innocuous piece of clothing endanger public order, especially when frisking can be employed? If there is an apprehension of protests over this manner of dressing that may spill into a public order issue, it is the demonstrators who must be controlled. The heckler's veto, a phrase coined by legal scholar Harry Calvin Jr. and first recognized by the United States Supreme Court in Brown versus Louisiana, 1966, is against the rule of law. The Supreme Court in Union of India versus K.M. Shankarappa 2000 had recognized the reality of divergent views in any democratic society and held that it is no excuse to say that there may be a law and order situation. It was categorical that the clear duty of the government is to ensure that law and order is maintained by taking appropriate actions against persons who choose to breach the law. The hijab verdict quoted Oscar Wilde that there is scope for improvement even in heaven, talking about the drafting of the GO. Now, the English playwright also quipped, "Nothing succeeds like excess." Now, this may be relevant for groups that seek to impose their stand on others on two extremes, from short skirts to headscarves. A display of modesty cannot be said to offend morality or pose a threat to health. The veil can be viewed as a sign of discipline, conforming to a religious instruction, even if it is not widely in vogue. It is not a fashion accessory like a bandana that would violate a dress code. Moreover, if it is of the same color as a prescribed uniform, what can the objections be? Tomorrow, if a cancer survivor with a tonsured head after chemotherapy chooses to wear a headscarf, would that too be disallowed? A nun wears a habit that includes a veil. It is her religious uniform. Will she too be banned from studying in certain institutions? What about a Sikh student wearing a turban, which is his legitimate attire based on his religion? Now, on the interpretation of freedom of religion, the Supreme Court in Bijo Emmanuel versus State of Kerala, that landmark judgment in 1986, had succinctly observed that Article 25 is an article of faith in the Constitution, incorporated in recognition of the principle that the real test of a true democracy is the ability of even an insignificant minority to find its identity under the country's constitution. There was a reference to verse 256 in the Holy Quran, "Let there be no compulsion in religion." But compulsion cuts both ways. And the petitioners were not before the court challenging the hijab, but the government order disallowing it on the ground that it violated the prescribed dress code. To quote Justice Jackson of the US Supreme Court, "If there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion." Let us pray that our Honorable Supreme Court takes a fresh look at this issue, and in the end, we are all left with what every religion preaches, which is peace.